Hello everyone, and welcome to today's presentation, GDPR Overview, What You Need to Know, brought to you by Clinipace Worldwide. Now, who is Clinipace Worldwide? Clinipace is a digital clinical research organization that pioneers innovative, technology-amplified services powered by our proprietary Tempo e-clinical technology platform. We also have a team of experts with extensive knowledge across many therapeutic areas, including oncology and cardiovascular disease. We serve venture-backed, mid-tier, and strategic pharmaceutical, biotechnology, and medical device firms. We are headquartered in Morrisville, North Carolina, but we have additional offices in the United States and across the globe in Europe, Latin America, and Asia Pacific. So what are we going to talk about today? What we're going to do is present a high-level review of the GDPR and how it changes the European privacy landscape. I will also provide some takeaway points to help you prepare for the GDPR. Note throughout the presentation, you're going to see some of the words in red. What that means is that those key pieces of information is a difference between the GDPR and the old 1995 directive. Okay, a few logistical items before we get started today. You will receive a copy of today's presentation along with a recording, and our Director of Marketing, Emily Nichols, will help follow up with you to make sure you received all the items. We welcome your questions throughout the presentation, so please go to the GoToWebinar controls with any questions you may have. We're going to try to answer all the questions that you have, but in the event that we run out of time, we will try to answer your questions for you after the presentation. Okay, a little bit about myself. I'm an attorney. I have been working at Clinipace now for 5 years, and I currently serve as the Global Data Protection Officer. And just a disclaimer before we begin, the laws and requirements in this presentation is in regard to the GDPR only. There are certain areas of the GDPR that allow member states to legislate their own laws with regard to certain issues. So please look at your member state laws with regard to certain issues that is silent under the GDPR. An example being HR data. Also, the information contained in this presentation is for information purposes only. It does not constitute an attorney-client relationship and does not offer any legal advice. Okay, let's begin. Okay, so the GDPR, let's look at the timelines and why it was developed. First, the timelines. The GDPR was formally adopted on April 27, 2016. And it becomes enforceable in May 25, 2018. So it gives you a little bit of a window of time to help get your program ready for the compliance with the GDPR. However, once you hit that May 25th date, it becomes fully enforceable and you could be subject to violations or sanctions. So why was the GDPR developed? Why did they make this new law? Well, there was a lot of things that were going wrong in Europe before the GDPR. One of it was lack of harmonization across different EU member states. Previously, you had a directive that gave you the bare minimum requirements that every member state had to incorporate into their laws. However, every member state had different set of laws with different requirements and different sanctions and severity for violations. So for a company doing business in Europe, it was very difficult for a company to navigate through all the different laws of every single country. So what the GDPR does is have one set of laws that is spread across the entire European Union, and you only have to adhere to that one law. Granted, as I said before, there are certain areas that member states will legislate, so you will need to look at member state laws for those particular areas. Another concern was that you had different supervisory authorities that you had to deal with from every member state. So if you were doing business in Germany and Belgium and France, you had to deal with every single supervisory authority, or also known as data protection authority, in each of those member states. So it became very difficult to have to communicate and provide information to all of these different supervisory authorities. Now, under the GDPR, you have a one-stop shop for all DP enforcement. So you have one supervisory authority that you need to be in communication with and to work with. Another complaint was lack of data subject rights in Europe. So what the GDPR does, it offers a higher level of rights for data subjects, including the right to sue controllers that violate the GDPR. Another issue is territorial reach. Before, only companies established in the EU were subject to EU laws. now you're going to see a greater territorial reach, and it can go after companies that may not be established in the EU. And we'll talk more about that later. And then lastly, the GDPR offers teeth in compliance with privacy laws. Before, supervisory authorities didn't have much in terms of government enforcement. Now they have much greater powers to enforce, to audit you, and then as well, penalties for non-enforcement. They're substantial now, and we'll talk more about that later. So let's look at some of the key changes under the GDPR. As I said before, you're going to see a much broader territorial and material scope under the GDPR. And what that means, territorial means, who will be subject to the GDPR, and material scope means what kind of data would be covered under the GDPR. Also, some key definitions have changed and have expanded, including personal data and sensitive personal data. Also, there's a new definition called pseudo-anonymous data that is also is new. And then also the consent definition has expanded as well. Also, as I mentioned before, you're going to have increased controller obligations and also greater rights for data subjects, and we're going to talk more about that later. Higher liability for controllers and processors, so that's new too for you processors out there. You are also liable under the GDPR, and that liability would be private cause of action for data subjects and then higher penalties and sanctions. And I just want to note with that private cause of action for data subjects, that also includes mandatory free arbitration for data subjects. It's free for the data subject, but it's not free for the controller. The controller has to pay for it. So just please keep that in mind as well. And then as stated before, greater powers for government bodies, including investigative, enforcement, and audit powers, as well as the ability to take controllers to court as well. Okay, so let's look at material scope, which is what kind of data falls under the GDPR. And it would basically be anything that is electronically processed, or it could be paper processing if it's part of a filing system. So as you can see, this definition is quite broad. The intent for this broad definition was to be technology neutral in nature. But there are some select exclusions to the material scope requirement, and that is anonymous data is not included. It will not be covered under the GDPR. Personal data of legal persons, i.e. companies, that would not be covered. Deceased data subjects are not covered. However, please note that under France's new law that just came out, deceased subjects are covered, so just keep that in mind. And then any processing activities that fall outside of EU law, that would include national security type issues, that would not fall under the GDPR, and any processing for personally household or personal purposes. Okay, so we looked at material scope. Now let's look at territorial scope. So there's two types of prongs that you can fall into to see if you fall under the scope of the GDPR. One is an old one, which is a company with an EU establishment. And basically that is where personal data is processed in the context of the activities of such an establishment. And that is meant to be a very broad definition. The European Court of Justice was clear that it's supposed to be interpreted broadly and in a flexible manner. So what kind of things would be considered established within the EU? So a company that would have branch offices in the EU and would market to EU data subjects, that would consider established within the EU. There was also a European Court of Justice case where you had a Slovakian property website that was considered established in Hungary when they advertised Hungarian properties, along with using a local agent in Hungary and then having a Hungarian bank account for commercial purposes. That was considered sufficient enough to be considered established within Hungary. So as you can see, it's a very broad definition, and you can have just one single agent or representative in the EU, and that would help trigger this requirement. And also, please note that the processing activities do not need to occur in the EU for it to be triggered. So if you're, if you have some establishment in the EU, but you're doing your processing activities in the US, you would still be covered under this prong. Okay, so what if you're not established in the EU? Well, you can also be subject to the GDPR if you're offering goods or services to EU data subjects, or if you're monitoring behavior of EU data subjects. So you can see that you could also be covered even if you have no actual presence within the EU. Now, what would not be enough to be considered offering goods or services? So if you just have a website where EU data subjects could access it, that is not enough. Or if you have an email address that they can, contact you, that would not be enough for offering goods or services. But if you have a website and you're targeting EU data subjects, you can have them buy goods or services through use of their currency, through like euros, for example, or if you have a website where you also have different EU languages as well as English, so you have English, but then you can click on German language or French language, that would be sufficient to be considered offering goods or services. Additionally, you don't actually have to get paid money to be considered offering goods or services. Just the attempt to try to get goods or services is sufficient. And even if you're offering your services for free, that is also considered covered under this prong. Okay, so we looked at material scope, we looked at territorial scope. Let's look at some of the definitions and what has changed. So personal data, which is a very broad definition, is basically any information that can identify an individual. And then they give some examples in the GDPR of what would be considered personal data. I'm not going to go through all of them, but please keep in mind of some of the changes of the definition between the GDPR and the directive, and that is the inclusion of location data, including IP addresses, online identifiers, cookies, and genetic information. Also, in terms of sensitive personal data, that has changed a little bit as well. And sensitive personal data is basically data that is offered a higher level of protection due to the sensitive nature of the data. And included with sensitive personal data would be race or ethnic origin, religious beliefs, data concerning health or sex life, and genetic data. And then I just put in the definition of data concerning health. It's basically personal data related to the physical or mental health of a person, including the provision of healthcare services. Okay, so we looked at what personal data is and what types there are. Let's look at what is not considered personal data, and that would be anonymous data, and that would be information that you cannot relate back to an identifiable person. That would not fall under the GDPR, but please be aware it's very difficult to be considered anonymous data. You have to, if you can exercise reasonable efforts to identify the person using different identifiers, either through like the public domain or through different sources, that would not be considered anonymous data. Okay, so that's anonymous data. We had personal data. There's a middle ground, and that is pseudo-anonymous data. And that is basically, in the clinical trials industry, we use a lot. It's key-coded data. It's information where you have information that is scrubbed of, identifiable information, but there's a key associated with that person, and that key is held in another location where it's kept secure and safe. And in the clinical trial realm, what you have is clinical subject data, where you have the hospitals collecting data. They remove all the identifiable information they provide to the sponsors and the CROs, but they keep the key, so they're able to identify the person based on that key. Now, pseudo-anonymous data is considered personal data, so it does fall under the scope of the GDPR. However, it's encouraged under the GDPR, and it offers a higher level of protections for controllers. So if you use the pseudo-anonymization techniques, you can show that you're using adequate measures to protect personal data. So it's a good thing to use. Another thing that has changed is a definition of consent. And consent is any freely given, specific, informed, and unambiguous indication of a data subject's wish, and this can be done through a statement or affirmative action that they consent to allow us to use your data, the controller. So what has changed? So now the consent has to be unambiguous. And what does that mean? It means that there cannot be any question that the person consented to the data. So you can't have silence as consent. You can't have pre-clicked boxes as consent. And you need to have the consent in such a way that the person, the data subject, knows what they're consenting to, what personal data that you're collecting, the purposes for which you're using the data, and then their rights as data subjects. So in consent now, you're going to need to have a signature or some type of manual process where the data subject actually clicks something to show their consent. But please note, in the clinical trial space, clinical trial subject consents are regulated under European Regulation 536/2014. So please look to that regulation for the requirements for clinical trial consent. Okay, so we looked at definitions. Now let's look at the general principles of the GDPR. There's 6 of them. The first one is that data must be processed in a lawful, fair, and transparent manner. And what does that mean? So lawful means you need to have a lawful basis for processing, and you can get a lawful basis either through consent, through contractual necessity, or through legitimate interest. And legitimate interest, there's different factors that you need to consider if you fall under legitimate interest. But the burden of proving legitimate interest is on the controller. In terms of fair and also transparency, you need to make sure that the data subject understands what is happening to their data, and that goes to consent and it goes to information notices, providing data subjects with who has access to their data, what countries do these people reside in, where is the data housed, where is it located, and then what are their rights as data subjects? You know, what rights do they have of access, of rights to object, et cetera. We'll go more into the rights later. And then also who they can go to if they have a request or a complaint, either at, in the company or at the supervisory authority level. So that's the first principle. The second principle is that data must be adequate, accurate, and relevant, and limited to what is necessary for the purpose. And what does that mean is, in terms of accuracy, it's pretty self-explanatory. If there's an error in data and the data subject, wants you to fix it, you need to fix the data to make sure it's accurate. It also needs to be relevant to the purpose that you're using the data for. If it's not needed, it's not relevant, then you shouldn't be collecting it. And it also goes to the limitation principle, limited to what is necessary for the purpose. And in the clinical trial industry, a good example would be date of birth versus the year of birth or age. So if you're looking at a clinical trial subject and you want to see if they're eligible to participate in the study, look at if you really need the full date of birth versus the age or the year. If you don't need the full date of birth to know if they're eligible, then you probably should not be collecting the full date of birth. You should probably be collecting the year. That would be an example of the limitation principle. Okay, so that's the second principle. Let's look at the third principle. Data must be collected in a specified, explicit, and legitimate purpose and may not be further processed in a manner that is incompatible with that purpose. So that basically means is if you're processing personal data, you can't say, I'm going to process all of your personal data for company purposes. That is incredibly vague. It's not explicit. It's not specified. What you need to do is say, I'm going to process your name, your email address, and your physical address so I can contact you for XYZ purpose. And then the second prong is it cannot be further processed in a way that's incompatible with the first purpose. So say you take their information, or in the clinical trial space, say you take the CV of the investigator, and the reason why you're collecting that information is for purposes of making sure that they have the qualifications necessary to conduct the trials and also to upload into the TMF. But what if you want to take that CV and then send it along to other members of your company to see if we can find ways to market certain drugs to them, to see what their interests are, what is their specialties? That would be a different purpose. So that would not be something that you would want to use that data for because it's an incompatible purpose. Okay, let's look at the next principle, which is data retention. Data must be kept in a form which permits identification for no longer than is necessary for the purposes for which the personal data is processed. So what does that mean? That means if you only need to keep the data for 3 years, once that 3 years time limit is up, you need to destroy that data and then document that you destroyed the data. Can't keep the data for longer periods. There are some exceptions for archival purposes and et cetera, but that's the general principle. The next general principle is security. Basically means, make sure that people who are not authorized to receive the data have access to data. Don't lose the data. Don't have, a data breach in some manner. And then lastly, accountability. The controller is liable for and must demonstrate compliance with the principles, and that demonstrate compliance is new. So that means you're going to need to have documentations in place to show that you are actually complying with these principles. And because supervisory authorities can audit you, you need to have that documentation ready. Okay, so we looked at the general principles. Now let's look at individual rights. So the first right is in terms of notice and transparency. And this is similar to what we were looking at the general principles. Basically, that is, data subjects have the right to be informed as to what kind of data you're collecting and the reasons you're collecting it and who you're giving the data to. And there's other things that you need to notify them as well. It's basically just trying to make it transparent in nature. And the way that you notify data subjects is through information notices. And there's a whole list of things that you need to include in the information notice, but it's basically just to let them know what's going on. The second right is data access rights. So now under the GDPR, data subjects can go to you and ask for a copy of their personal data. So you have to provide that free of charge to them. There's some exceptions to that rule, the exception being if the personal data has trade secret information or intellectual property information that could be damaging to your company. There are some limitations there, as well as if other data subject rights may be violated if you provide that information to the other data subject. Those are some exceptions, but as a general rule, you are to provide a copy of their personal data if requested for free. There's also some exceptions to the free requirement. If they do excessive requests for information, then you could provide make them pay a little surcharge for that. Okay, the next right is the right to rectification and erasure. So rectification is basically if there's an error in their data and they tell you there's an error, you have to fix it within a certain time frame. Same thing with erasure. There's certain criteria that must be met for them to be able to erase data or opt out as it is. Basically, to meet the opt-out test, the data is no longer needed for the original purpose, or that the subject withdraws consent, if consent was the legal basis for processing the data, or that the subject objects and there's no overriding grounds to continue processing. Those are some examples. Or if the data was originally processed unlawfully as well. The next right is the right to restrict or object to processing. So there are certain ways that they can restrict certain types of processing or certain data being processed, as well as to object to processing. And the objection goes to, they can object to processing generally, but there are some exceptions to that rule. There are no exceptions if the objection is due to direct marketing. So if you're objecting to a company directly marketing you as a data subject, there's no exception to that rule. They can object, and then you cannot do that processing anymore. But there are some exceptions, but the controller has the burden of proof in this. So you, as a controller, need to show a compelling legitimate ground for processing that overrides the data subject's interest in opting out, and or the data is required for the data controller to establish, exercise, or defend a legal right. Okay. Next right is data portability rights, and this basically means that subject can have a copy of their data in a machine reasonable format, and they can take that data and they can give it to another controller. Once again, there are certain exceptions to this rule, one of them being if there's intellectual property or trade secret compromise, you may not be able to transfer to another controller in that respect. There is an exception to all of these rights, and that would be in the event that the controller cannot identify the subject. So if you can't identify them through anonymization techniques, then you don't have to comply with these rights. What is the time frame for complying? So if a data subject comes to you and says, I want to exercise my rights, you have 1 month to comply with the data subject's rights. If you have a lot of requests at one time, you do have up to 2 months then. Okay, so those are the individual rights. Let's now conversely look at controller obligations. And a lot of this is similar to data subject rights. There are 3 buckets of obligations. The first one being transparency and notice rights, which we discussed earlier, making sure you provide complete information notices, making sure that you provide adequate consent if consent is your basis for processing, and then providing notification to data subjects and the supervisory authority in the event of a breach. Certain breaches will require notification to the supervisory authority and or data subject, so look at the requirements to see if you have to notify. If you do have to notify, there are time limits as to when you can notify. For supervisory authorities, you have to notify them within 72 hours of knowing about the breach, not a lot of time. For notification to data subjects, it's without undue delay. Okay, let's look at the next bucket and then look at accessibility rights. The first one is data retention. It basically goes back to what we were talking about before, the principles that you can only hold on to data for as long as it's needed for the purpose, and then you must destroy the data or anonymize it in a fashion that's no longer identifiable to the data subject. And you have to document that you did this. Next, handling data subject complaints and requests. And as stated before, there's a time frame to do that, and you need to have a clear process in place to make sure that you can handle all those requests. And lastly, you need to communicate and cooperate with the supervisory authorities with any requests or inquiries that they may have. Okay, let's look at the next bucket, and that's accountability. So the first thing is you need to make sure that you have your security and organization requirements in place in order to comply with the requirements. Next, this isn't required, but the GDPR encourages you to use technology to help protect the data, and that is the privacy by design and by default. Also, you need to adhere to internal records and documentation requirements, so make sure that you have that in place so that you can provide this to your supervisory authority if they audit you. Next, if applicable, you need to appoint a data protection officer, and there's a whole list of rules on what you need to do to see if you need one. And then lastly, if your company engages in high-risk activities, notably if, for example, you're engaging in large-scale processing of sensitive data, like health data, for example, you may need what they call a Data Protection Impact Assessment, also known as a PIA. And this can be done in-house, or you can go to an external consultant to help you with this assessment. Okay, so that was controller obligations. Now, let's look at why it's important to comply with these requirements. Why should I comply? Well, the consequences for noncompliance is quite severe. As stated previously, the sanctions have increased, and you can be fined up to $100 million or up to 5% of your annual worldwide revenue if you fail to comply with the requirements. Also, as stated before, data subjects now have a private cause of action against you to seek damages, and you need to provide them with free arbitration. Additionally, the government can ban you from processing activities, and they can also prohibit cross-border data transfers. Also, the supervisory authority can commence legal proceedings against you as well. So you can be in court with supervisory authorities, you can be in court with data subjects as well. And then lastly, the reputational harm of being found to violate GDPR could be quite harmful to companies. Okay, so we looked at the GDPR, what are the requirements, and then why it's important. Let's look at some practical takeaways to consider when trying to set up your privacy program. The first thing I would look at is appoint a DPO if it's required, or a privacy leader. So even if you don't need to appoint a data privacy officer, I would at least appoint a leader to help you get your privacy program off the ground. There are a lot of requirements that you need to adhere to in order to comply with the GDPR in a short period of time. So having that leader will be very helpful to you. Next, I would conduct a data mapping exercise, and that's basically going to help you determine where your data is located, what kind of data you're collecting, who has access to the data, and in terms of locations, what countries people have access to data, and also what kind of computer servers they're on as well, and where those servers are located. So that will help you determine how to set up your data privacy program based on that data map. After you conduct the data map, I would create a GDPR action plan. And you can do it any way you want, you can do, but I would do time limits. I would say, I have to do A, B, and C by X period of time, and I could do, C, D, and E by another X period of time. I would set time limits so you clearly know what you need to do and when it needs to be done. If needed, I would conduct that privacy impact assessment next and either do it in-house or use a consultant to help you. Then I would look at your internal procedures and policies, and specifically I would look at complaint handling process for data subjects. I would look at your data breach policies and procedures because of those time frames. I would maybe even look at your data breach procedures first, because I would think that would be the most important one to look at due to that 72-hour requirement. So look at those and update them or create new ones if you don't have one. Also look at your templates, your notices, your information notices, your forms and contracts, and update or create as needed. You're going to be obligated to make sure you have data processing agreements if you're a controller with your processors. So make sure you have those agreements in place. Also, if you're contracting with investigators, with hospitals, you probably want to make sure you have adequate data protection language in those agreements, and also your vendors as well. Any vendors that you're working with who may have access to data, you want to have data protection language in there as well. Then, if you're taking data and you're transferring it to countries outside of Europe, look at the mechanisms by which you are transferring that data. What are you using to lawfully transfer data? And I would say look at your motto clauses. I would look at Privacy Shield certification, and also codes of conduct as well. Next, make sure you train your staff on the GDPR, what it means, what are the requirements, and then what we have to do to adhere to the GDPR. So they're the ones that are on the ground. They're the ones who are going to be having access to data, who are going to be using the data. So they really need to understand what they can and cannot do with the data. Next, I would look at your compliance documentation and registrations and make sure everything is organized properly. I would make sure you start documenting everything you're doing in terms of your data privacy program. So when the supervisory authority comes to you and says, what are you doing? You can say, this is what I'm doing, A, B, C, D, etc. Another thing to consider is your insurance policies. With all these new requirements in place, you want to make sure that a data breach that happens or a violation of the GDPR is covered under your insurance policy. It may not be, and you want to make sure that you're covered. Another thing to consider is look at the 29 Working Party opinions, and the 29 Working Party will soon become the European Data Protection Board, so just note about those two different name changes. But there's a lot of opinions that they're putting forth. They have a whole action plan that they have in place of putting out opinions. They've already put out 3 already, which I stated previously, but they're going to do some new opinions coming up soon. Notably, consent is one of them. So I would definitely take a look at those opinions. I would also, be breached on all the new member state laws that are coming into effect. France has already implemented, and it's fully enforceable now, their law. So take a look at those member state laws as well. And then lastly, if you can, try to use technology in innovative ways to protect the data using privacy by design or default mechanisms. Okay. That's it for the presentation, but please stay tuned. For next in the e-learning series, we're going to have a practical workshop on how to prepare for the GDPR. We're also going to talk about the current state of cross-border transfers and clinical trials. There's a lot of stuff going on with cross-border transfers right now with the Facebook litigation going on. They're trying to say that a lot of clauses are not valid. Also, Privacy Shield has come under fire recently, so we want to talk about that. And then lastly, data breaches in the GDPR and how you can prepare to make sure that you have a good data breach policy in place. Okay, that's it for me. I'm going to go now to the question and answer session, so just give me a moment. I'm going to take a look at some of the questions. Looks good. Let me see. Okay, so first question. Are the regulations fully established? Will any regulation change before May 25th? Good question. So currently, the regulations are formally adopted. However, they're not enforceable until May 25th, 2018, which means that they're not going to prosecute you for violations of the GDPR right now. But what that means is they're giving you time to prepare for the GDPR. What I would look at, though, as stated before, is the member state laws, because they're updating their laws right now. For example, France has already implemented their laws, and I think that if you violate their laws, it's up to $3 million in sanctions. So please take a look at those laws and make sure that you're compliant right now. Let's see. Oh, good one. Does every company need a data protection officer? Good question. No, you do not. There is a certain test that needs to be performed to see if you need a data protection officer or not. So let's look at that really quick. So there is a test. The test is, does your company engage in regular and systematic monitoring of data subjects on a large scale, or are you processing sensitive personal data on a large scale? So if you meet one of those requirements, you will be required to have a DPO. And I would like to mention that the 29 Working Party has put a really good opinion out on the DPO requirement and whether you need one or not. So please take a look at it. I think they put it out on December 13th of last year. So take a look at that opinion, and that will help you. One thing in that opinion I read, the 29 Working Party stated that you need to have a good analysis in place as to why you need or do not need a DPO. So don't just look at it and say, well, I don't really think I need a DPO, so I'm just not going to get one. I would engage in a formal analysis to really see whether you need one or not. If you have in-house counsel, maybe have them help you conduct that analysis, or can use outside counsel to help you. But have that in writing and in place, so when the supervisory authority goes to you and says, so why do you think you don't need a DPO, you can say, here's my analysis. And they specifically stated that in the opinion. Let's see, what else do you guys? What do you consider large scale? That's a really good question. So let me just pull up this for a second. The 29 Working Party did a whole analysis on what it constitutes as large scale. Right here, okay. So the GDPR has really no formal definition as what constitutes a large scale. However, the 29 Working Party gives many factors to consider. For example, the number of data subjects concerned, either a specific number or a proportion of a relevant population. You also want to look at the volume of data and the range of different data items being processed, the duration or permanence of the data processing activity, and the geographical extent of the processing activity. There is a brief mention of large scale in Recital 91 of the GDPR. They were more talking about impact assessments when talking about large scale, but you may be able to apply it to the large scale definition in the DPO requirement. And what Recital 91 says is that large scale is a considerable amount of personal data at the regional, national, or supranational level, and which could affect a large number of data subjects and which are likely to result in a high-risk processing. Exceptions, personal data from patients or clients by an individual physician or other healthcare professional or lawyer. So basically what they're saying is if you're an individual doctor and you're seeing lots and lots of patients, you're not going to fall under that large scale requirement. And same thing as a lawyer. If you're seeing a lot of clients, you're not going to be covered under this large scale definition. Oh, they did give some examples. Processing patient data in the regular course of business by a hospital, that would be considered large scale. And then processing of real-time geolocation data of customers of an international company for statistical purposes. That would also be an example of large scale. See. Just looking, you guys have a lot of questions. This is really great. Let's see. Oh, are there slides available for download? Yes. At the end of this presentation, Emily Nichols, who is our Director of Marketing, will provide you with a copy of the recording here, as well as a copy of the slides. What exceptions does the GDPR grant relative to research data as compared to other personal data? Very good question. The GDPR does have exceptions for personal data used in the process of research, statistical, and archival purposes, and they're throughout the GDPR. There's many different exceptions for those kind of activities. Most notably in some of the data subject rights. So some of the rights of data subjects may be limited if you're doing statistical research or archival activities. Oh, this one's a good one too. You guys have great questions. Could the compliance, privacy, or security officer located in the U.S. be appointed as a DPO or privacy leader? Okay, for the DPO requirement, which is the requirement under the GDPR, I would say no. And the reason for that is conflict of interest. The working party, 29 working party, specifically states that the CSO, the chief security officer or head of IT, or people who are heads of marketing or HR, or people who are in senior levels of management in operational capacity should not be the DPO due to conflict of interest. So I would say no. You should have a separate DPO. Now, in terms of you already have a general data protection officer in place, like if you have a global company, that one is more debatable. I guess there could be some construing of conflict of interest, but what I would do is I would seek outside counsel, and because you would need to know the particulars of your particular company to see if it would be a conflict of interest. Let's see. Lots and lots of questions. Yeah, oh, this was another great one. Are research staff conducting the study also considered under this law? Do we need to ensure that they too understand that some of their personal data may be shared? Yeah, I would say yes. I would say yes, they're covered as well. Your types of personal data would be CVs of investigators. In some countries like Poland, you're getting banking details from individual study staff. So things like that, yeah, you would definitely need to consider getting either consent from them or some other mechanism in place to make sure that you can adequately and lawfully process that data. And what we're doing, for example, is getting consents in place to make sure that we can lawfully process that kind of study staff data. Good questions. Let me see. Oh, good one. How does the GDPR relate to Switzerland? What DP authority will Swiss entities doing business in EU be subject to? Good question. I was just reading about this the other day about Switzerland, and it's unclear right now. Well, Switzerland is its own country, but it is unclear how the GDPR will affect Switzerland. I would say take a look at the news and see what's going to happen at this point. I would say it's unclear right now. In terms of cross-border transfers, just to let you guys know, Switzerland has now updated their privacy shields for Switzerland, so I think we're ready. You're going to be ready to start certifying under the privacy shield for Switzerland soon, so take a look at those requirements as well if you're doing cross-border transfers. Very good questions. Very good questions. Oh, this one's another good question. For a clinical study that will start in 2017 and will continue to 2018-19, do we need to include now a statement in the informed consent that the data will be collected in compliance with GDPR? I would say yes, and the reason for that is that the data that is being collected after April of 2016 would be subject to the GDPR. So what you're doing with the data now, you'll not be, you won't be prosecuted for it, but it will be relevant. So I would start preparing now so that when the enforcement date comes up, you already have everything in place with regards to that data. So I would say the answer to that question, yes. Lots of good questions. Are there any responsibilities for employee participating? Oh, another good question. Are there individual responsibilities, possible penal sanctions to employees participating and/or endorsing undue data processing? I think that is unclear at the moment. They do say specifically for the data protection officer that you're not going to be personally liable for any violation of the GDPR. I don't know if individuals will be liable. Possibly the heads of the company may be liable, but I would say that at least if you're the DPO, you're not going to be liable. Let me see. How does this EU requirement apply to sponsors conducting trials at U.S. sites where the law does not apply? So I would say if you're a U.S. sponsor and you're conducting trials in the U.S., the law would not apply. I think if you're an EU company and you're doing trials in the U.S., I would think that the law would probably not apply, but I think it's unclear at this time, and I think that hopefully we'll get more guidance on that from the 29 Working Party. But that's a very good question. What skill sets are required for a data protection officer? That's a very good question. So basically, data protection officer has to have a certain expert knowledge in the legal requirements of the GDPR and European data protection law, so they need to have expert knowledge in that field. They also need to have a level of understanding of security requirements with regard to the data, and they also need to have no conflict of interest, as I stated before. So those are some of the requirements of a DPO. So no conflict of interest, technical and legal knowledge of data protection laws, and security requirements would be the biggest ones. But there's a whole list that is mentioned in the 29 Working Party guidance that you should definitely read. Yeah, so there seems to be a conflict on retention requirements with FDA requirements. So the data retention requirements state that you can't keep data for longer than what is needed for the purpose. So I would say if there's FDA requirements that say you need to keep it for this time frame, then that would be sufficient to show that you need to keep it for the purposes of legal compliance. But please note that the GDPR states that if you're trying to comply with other laws, the EU laws will trump that. So just keep that in mind. Oh, good one. Does the GDPR affect non-for-profits that operate in the EU? I believe there's an exception for nonprofit organizations. I can double check that, but I think nonprofits may have an exemption in terms of some of the requirements. Okay, let's look at time. Okay, well, I think that we're well over now, so I think we're just going to end the call at this time. But I'm going to take a look at these questions, and after the call, we're going to provide answers to you. Emily Nichols will provide these answers. So without further ado, thank you so much for joining this call today, and I hope you have a wonderful day.